And welcome to the open meeting of the New York City Conflict of Interest Board. At this meeting, we're going to consider amendments to three groups of rules relating to annual disclosure, gifts from friends and family members, and post-employment restrictions. For the purpose of this meeting, I'll designate Julia Lee to be the recording secretary. And we can begin. And the first rule we'll consider are amendments to rules 4-01, 02, and 3, which deal with annual disclosure and requests to delay filing. So perhaps Julia, who is, of course, the Director of Annual Disclosure, could begin and take us through the proposal.
Okay. The proposed amendments to Board Rules Sections 401, 402, and 403 codify current annual disclosure filing procedures and terminology and eliminate provisions that are no longer relevant in order to provide more accurate direction to filers. These rules were promulgated many years ago, and since then the filing process has changed significantly, most notably the transition from paper filing to electronic filing. As a result, many of the practices and procedures outlined in these rules are no longer applicable, and while the general content of the rules remain the same, they have been streamlined for conciseness and to reflect current practices. So I'll briefly go over the three rules that have been amended. The first rule, proposed Board Rule Section 401, addresses the procedure which allows filers to obtain an extension of time to submit their reports. When this rule was first promulgated back in the early 90s, the requests for extension, additional documentation, and the subsequent decision were processed through regular mail. Now, today, those requests are processed by email, a much more expedient mode of communication. And thus, the biggest change for this rule is that it gives filers additional time to make that extension request. This rule also provides clearer guidance on the basis upon which an extension of time is granted or not granted, and also retains a period of 4 months as the maximum amount of time a filer can be granted an extension. Overall, the rule is more concise. It removes references to procedures relating to paper reports as well. For example, there is no longer an option to seek an extension to submit partially completed reports, which were allowed during paper submissions. The electronic filing application does not accept incomplete submissions, so any reference to partial reports have been removed. The second rule, proposed rule section 402, is the retention rule, and it keeps a 6-year retention period for all annual disclosure reports. The retention period starts on the date the report is filed with the board and ends on the 6th anniversary of December 31st of the calendar year the report was related to. I did want to alert the board that there was a change made in the statement of basis and purpose, which is Exhibit 2, page 4, line 2. The example that was in the statement of basis and purpose is just a little confusing, so to make it a little easier to understand, it was changed because currently it reads, for example, a report filed in 2014. That has been changed to just read a 2013 report. It's clearer and easier to understand. So basically, the example is that if a 2013 annual disclosure report is retained until December 31st, 2019. Beyond the 6-year retention period, the board can retain and will retain reports past the retention period upon a timely request by a law enforcement agency and extend it as necessary or until the matter is concluded. There is another change also to the statement of basis and purpose to be consistent with the wording of the rule. The change is on line 4 in the same paragraph. Instead of the rule would permit, it now reads the rule would direct. That's consistent with the rule, which basically says that the board will retain those records. The law enforcement matter covers both enforcement of criminal and civil matters conducted by law enforcement agencies. It is not restricted only for criminal investigations. And finally, the last rule, proposed Board Rule 403, is simply a more concise and clear revision of the current language, which defines city employees holding a policymaking position as filers with substantial policy discretion as defined in Board Rules Section 1-02.
Just a question on the civil or criminal enforcement agencies. The language talks about agencies that have authority in part, whole or part, pertaining to the enforcement of criminal laws. The previous language talked about law enforcement. Is there a reason I understand it's not our intent to restrict this to criminal, but is there a reason for the change in language? So if this is in 4-02B, that in talking about the agencies for which we will retain the records, it's DOI, or any government unit or component that performs as one of its principal functions any activity pertaining to the enforcement of criminal laws. Could we not change that to law enforcement?
Yeah, I mean, the rule basically has law enforcement agency. So it's not, I mean, including COIB, which we don't do criminal matters, we do civil enforcement matters. So that does include both civil matters and criminal matters as well.
Maybe I'm missing something. That was the existing rule, but the new proposed rule reads somewhat differently, is what I'm saying. Maybe I'm missing something.
Where are you looking at?
I'm at 4-02B.
Yeah, page, this is Exhibit 2, page 5,
Page 5, yes.
24 and 25.
The line 24, performs as one of its principal functions any activity pertaining to the enforcement of criminal laws. Should it not say enforcement of law or law enforcement?
Yes. You're right. Okay, I'll take that out. Sorry.
So what would we read now? The enforcement of laws?
Enforcement of laws, yes.
Or of law? Yeah. Okay. That was my comment. Now also, we took out partial request for the retention, an extension for partial filing. I understand the online system doesn't permit that. But so if there's a specific item that you need a delay for, what does the filer do? Request a delay for the entire document?
Yes. They would have to request an extension to file their entire report at a later time.
The entire, okay. And just finally, and just for clarity, the 6-year period, are we required, well, 2 questions. Are we required to destroy the records after the expiration of time? Is that a requirement? Second, if law enforcement requests it, must we keep it? What if there are pending requests at the time? Those.
So the 6-year retention period does require us to destroy the reports after the retention period is over. The law enforcement agencies, if there is a pending investigation that's going on, then we keep those records open until the matter is concluded. There hasn't been a reason not to retain those records. We don't ask the details of the investigation. We base it on the statement of the law enforcement agency, and then they usually give us an investigation number of some sort and give us updates on the status of it. And based on that request, we keep those records open.
but we do at the end of 6 years. Otherwise, we consider this to be a mandate that we destroy it.
Yeah, the administrative code basically requires us to promulgate a rule about our retention period. So in the past, there was language regarding the actual destroying of paper records. We actually obviously don't have paper records anymore. So the retention really is, we have this document, this report is in our possession and able to be disclosed for public inspection up to this period of time. And after that, the report does not exist.
Okay, clarifies that. Any other questions or comments on this rule? Well, actually, the only other question I have is on the 6-year period. Would it be more clear if we were to say we retain it until the close of the calendar year, 6 years after? That might make that a bit more.
That's fine. I can insert after the close of the calendar year.
Well, yeah, that might work. Are there any questions and comments from the board on this these proposed food changes?
No, sounds good.
Okay. If not, I call for a vote to approve the proposal. Your ayes?
Aye.
Negative? You're no negative? Okay. So it's adopted. The next step now Julia, is where is it in the process? We now send it to the law department? And,
That's correct. We send it to the law department and the mayor's office of operations for review.
Okay. So the next rule before us relates to gifts from family members and close personal friends. I guess Chad is in charge of this one, so maybe take us through the proposal.
Sure. So proposed revisions to Board Rules 101C have sort of two principles in mind. The first is that the existing rule at 101C has just sort of one standard for the acceptance of otherwise prohibited gifts by public servants from family members and close personal friends. And the thought was that this was bundling together two groups of people who are actually different enough that we might think it would be worth treating them separately. Family members having sort of this tightly defined meaning as sort of close kin, your parents, your siblings, your children. And then close personal friends, which actually just means anyone else who we might consider on the standard articulated to be an acceptable giver of a gift on a substantial life event. Usually we talk about these things in the context of weddings, the birth or adoption of a child, sort of real milestones in one's life. And then the goal was to separate out how the board considers those two types of people. And then the second principle was to look at the standard that was being applied and to try to create something that was a little bit more concrete and maybe a little bit more user-friendly for the regulated parties. The existing standard has sort of these four factors which might be helpful to the board in trying to evaluate whether or not a certain gift was otherwise impermissible. But in the context of the recipient of a gift, our experience has been these standards have been less helpful in helping people figure out whether or not they can accept gifts. And sort of the principle of the gifts rule being that it should be something that a reasonably sophisticated person subject to our law would be able to use to guide their own conduct, especially in the context of these gifts specifically, where a public servant is often in sometimes the worst position they might be to independently evaluate whether or not a gift would be prohibited, where they have somebody who they identify as a close personal friend who does have business with the city, and the nature of the conflict is such that perhaps they don't have sort of a firm enough footing in the law to impartially evaluate these things for themselves. And the existing rule sort of doesn't provide clear enough signage for a public servant to find themselves in that situation, and either to make a decision on the basis of sort of objective criteria or to guide them to us with an informed question. Often these questions come to us sort of while people are having these life events, and they come to us almost effectively unrooted in the actual regulation that's been promulgated. They just come to us sort of as academic questions, which then staff and the board are able to handle. So the proposed rule separates out this standard into two sort of prongs. The first one, I proposed 101, and I think it might be helpful to work from Exhibit 2, which has the old rule and the new rule side by side. So the first one, proposed 101C1, proposes that public servants are permitted to accept gifts on the substantial life events from family members. And the family member defined at C2 is this sort of narrow set of close kin. And then with respect to close personal friends, proposed rule 101C3 articulates what we might call sort of two steps. The first being that the public servant has to have a relationship with the giver that's, the language in the proposed rule is independent of and preceding public service, though we sort of understand that that might have like a temporal meaning, that you have to be friends before, and we sort of understand that that might not be entirely what the board's trying to capture. Really, we're trying to talk about sort of a substantial relationship that exists independent and separate from a public servant's city work. And then as a second factor, a public servant would be prohibited from accepting a gift from a person, even if they had such a close relationship, if that person had a particular matter pending before the agency. And the goal there is to provide sort of a real floor to the application of the rule, that there's going to be gifts that they can't accept, and that there's sort of an objective way to measure whether or not they can accept those gifts. And so, again, with the idea that public servants have lives, they have relationships with people with whom they deal, but there should be rules about how sort of the standard rule is always that you're not allowed to make new best friends in city government, that once you achieve a sort of a position of responsibility, the people who you interact with aren't becoming your new best friends. They're not buying you a car for your wedding or the birth of your child. And the idea being sort of to provide something that's a little bit more concrete for public servants that guide their conduct in these situations.
Any comments on this or questions? Members of the board?
I have a couple questions, if that's okay.
Yeah.
Chad, so I agree with breaking it down. I think that's a good approach between family and friends and acquaintances. My first question is with respect to the family rule, C1. Are there any guardrails to that? Then are we just basically saying that if it's a valuable gift from a family member, then it's allowable? So
it's a valuable gift from a family member on an occasion where it's customary. So it's a valuable gift that is customary on a family or social occasion from a family member. So there's this relationship that has to exist, that this person has to be your parent, sibling, child, and it has to be on an event that this sort of gift would be appropriate: wedding, birth or adoption of a child.
I just want to interrupt there. I think the substantial life event is borrowing from another concept. Yes. Family or social occasions, I think we've thought of more broadly. It would be, hey, we go out to dinner every year on your birthday. That's okay within the B5 context. That's different from the, yep, okay.
I apologize for that. There was so in this situation, people would be permitted to accept gifts from their family members, being this narrow universe of people, on all of these types of events. And there would be no other sort of cap on that, though of course the board could impose one if it wants.
You get a birthday present every year.
A birthday present every year would be sort of encompassed in this, that if your sibling was somebody who had a firm that did business with the city, they would be permitted to give you a birthday present every year in excess of the $50 limit.
Can you repeat that? If your sibling gave you a birthday present every year, it could not be above $50?
No, they were permitted to give it that to you in excess of the $50 limit. They were permitted.
$50.
That this is the provision that will permit such activity.
Now, what about, it's not here, but what about gifts by family members on non-traditional, on other occasions? So if a parent wanted to transfer some wealth to a child, and the parent is doing some business with the city, not necessarily the agency, but with the city, is that prohibited currently?
No, we would consider that to be permitted under this provision. That if a parent was sort of making transfers of wealth to their child or other types of gifts, we would not consider that prohibited by this.
But that would not be on a family or social occasion, would it? I mean, that's a concern. Or dealing with a situation outside the parameters of this rule. You get a gift from a family member. That's fine, even if that family member is doing business with the city at the time, or doing business with your agency. This doesn't necessarily deal with that. This is a broader question. I don't know if you've looked at that or anyone's ever asked that question.
No, that's an interesting question, Jeff. I don't know that we've ever been asked that question. I don't have a recollection of ever seeing that sort of family members transferring wealth sort of question in the context where, you know, let's say the parent transferring wealth to the child and the parent actually has business dealings with the city. I don't know that we've done that, but this rule is definitely, this is taking the language right out of the charter about family or social occasions, and so this rule wouldn't address that thing, that sort of circumstance. And we might, you know, that might be a thing that we might think about regulating separate from this, though the fact that we've never been asked that question makes me think maybe it's not a terribly urgent concern as just like a factual matter, but maybe that's just because no one's asking us and it's happening.
Under the strict language of the charter, probably would not be permitted because the exception relates to family or social occasions. So it's something to think about.
I mean, it would be an opportunity. It would be a matter of first impression for the board, and there's especially in the context of this wealth transfer or maybe like estate planning type event. There's a number of issues.
Or just a large gift to a child.
Or just a large gift.
Yeah.
It's one of those that's got to be okay, right? And if it doesn't fall within the charter exception, then probably the only way to deal with it, absent a charter change, is a waiver. But we've never been asked it, right?
Never, as far as we know, we've not been asked. But I think you've identified that there would be ways that the board would be able to permit such transfers, even if it found that it was a violation of one provision of the statute or the other.
Following up on Fernando's question about guardrails for family members. So under this provision, if your brother-in-law is doing business with your agency or has a matter before you, he can give you a gift on your birthday. You know, we define family member pretty broadly, you know, and we expanded even a bit here. So that if you have a relative, a friend is prohibited under this proposal from giving you a gift if he has or she has a particular matter before your agency. If you have a relative, it could be a fairly distant relative under these definitions, but distant meaning, you know, not personally close. It could be a brother or a step relative. Can that person give you a gift, even though the person has business dealings, a particular matter before your reason. Doesn't seem to prohibit that. Under this,
Yeah,
it's,
as drafted, yes, it would be, the rule would permit that, but of course, if the board would want to restrict that sort of thing, or to either in terms of restrictions on whether or not the giver has business with the agency, or to narrow the scope of family member, it wouldn't be difficult for us to do.
That dovetails into my concern, I guess, when I read it at first blush, is that it's sort of the default rule here is that if it's a family member and it's a gift for a family or social occasion, then it's fine, then accept it, notwithstanding that the family member has business before the city. And I appreciate what you're trying to do here is to simplify it. But one thing from the old rule is that it did allow for nuance and brought in other factors that enabled the board to take into account things like appearance issues. You know, so I mean, hypothetically, if you have a father and a daughter, or father has business before the city and the daughter gets married and he's got a big deal coming up in front of the city, and he gives her a huge wedding gift or something, I don't want to, I'm not saying that I'm casting aspersions at what his intentions are, but the appearances start to look really, they start to be concerning. You can imagine a set of hypotheticals where the appearances of the ethics start to call into question. And under this rule, we can't really bring that in.
The father might want the prohibition, Fernando.
There you go.
One thing to keep in mind here is, of course, public servants, acting in their city jobs can't act in ways that will benefit their associated parties. And while associated is a narrower set of relatives than the set here, there's that's a little bit of a built-in safeguard. I mean, that is to say, your father can give you under the proposed rule, your father can give you a gift on a customary family occasion, but you can never be working on matters in your city job that benefit your father. So, the prohibition there, your father might be prohibited from giving you a gift because he's doing business with the city, but you're not working on that business.
So you think
one solution to make the category?
B3 would weigh against that.
Right.
Okay.
Right.
So that I think might alleviate some of the concern here, right? It's not like your father can be giving you a gift while you're working on a matter for your father. If you're working on a matter regarding your father, you've already got a conflict of interest problem. I'm sorry, Wayne, go ahead.
Ethan, I don't have the definition in front of me, but how much trimming would be necessary, and would it be wise to make it coterminous with the associated relative definition?
It wouldn't require a lot. So associated does not include the parent.
Doesn't include, it doesn't include your grandparents.
No, it would be a lot. It would be a lot.
Yeah.
It's a much, we expanded the group to try to capture what 2604B5 is, which doesn't use the definition of associated. It says family or social occasions, and we're just trying to strike a balance. I think as a practical matter, the board has never said no to a parent giving a gift to a child on a wedding, or would prosecute a parent for giving a big gift to a child at a wedding. I mean, these are, like, as a practical matter, we're trying to put our arms around a group of family members that we think captures the category of 2604B5, which says these gifts are permitted. The charter already says these gifts are permitted. So what is customary in family or social occasions? And we just want to have like sort of a bright line rule. That's the goal on family members.
On the definition of personal friend, maybe more work needs to be done on that, because I'm not sure what independent of city service means exactly. And preceding city service is arbitrary. mean, I could, depends on how long you're in city service. I mean, certainly the city service for an extended period of time, as some of us might have been. One certainly makes and acquires close friendships over a period of time that includes the time one is in city service.
Yeah.
Independent, I'm not sure what independent of city service is, because that, at least in my case, many people with whom I've worked in city service, or maybe not many, but some certainly, maybe even in this room, are people who I would consider a close personal friend. So I wonder if we could work a bit on that definition.
That makes a lot of sense to us, Jeff. Obviously, like, we were having like phrasing troubles, but actually the things that you're articulating are things that we were trying to capture.
Right.
We seem to have missed the mark a little bit on independent and proceeding. We'll rework that phrase there, because you're right. The intention is not to prohibit people from acquiring new friends over the course of their city service, or from making friends with people who they deal with in their city jobs. The goal is to require that the friendship is not because of the city job, that
Right.
if you perhaps left or moved on from the city job, you would retain that friendship. This person isn't dropping out of your life. That's sort of the heart of it, that there has to be something more than just the professional association, which we'll try to capture a little bit.
Right.
Right. I mean, the kinds of questions we frequently ask are things about, like what kind of socializing are you doing with this person outside of city service? Is it just like, whenever you see them during your city job, you're hanging out and enjoying each other's company? That's not the kind of independent friendship that we're really talking about here. That's having a friendly relationship with someone with whom you work. But that doesn't get us to the kind of friendship where we feel like it's appropriate for somebody to give you a gift because it's independent enough from your city job duties for us to feel like it's not motivated by the performance of your city duties.
Okay.
I don't think we understand what we need to do there.
Yeah.
It's just going to be a question of wordsmithing that procedurally, this is the first time the board is discussing this at a public meeting.
Right.
So this will be coming back to the board with sort of edits to address that concern, and that's something we'll try to fix.
It's possible, Chad, that other jurisdictions have taken a crack at this, and maybe somebody's got some language. I mean, it's hard to. I mean, the kind of questions I used to ask was, have you ever been to their home, and have they ever been to yours? Of course, during the pandemic, that doesn't work quite as well, but those kind of practical questions, are there really somebody who you know outside of work? But maybe somebody's got some magic language in another jurisdiction.
Yeah.
So you'll bring this back with proposed language that addresses the comments
And
members of the board.
from what I'm understanding, it's
Yeah.
in addition to sort of this independent and proceeding issue, it's maybe trying to sort of address certain concerns about the scope of the family member gift, that maybe there might be
Right.
thinking about either narrowing the scope of permissible family members or including some sort of additional provision like after the provided that in 3. Either or.
Well, let's see which works. Okay. Are there more comments on this before we now move on to the next proposal? Chat again on post-employment.
So
Gee,
these proposed rules returned to us from the law department after receiving the certification of the law department and the mayor's office of operations. So we have said this is the first time that Nisha and Wayne have had the opportunity to see this. So, procedurally that's where it is, but conversations like by no means sort of set on this, and the language isn't locked in. It's, the board can change anything it wants in there. And the proposed rules are intended to sort of codify the board's interpretation and application of the post-employment restrictions found at 2604D. And the law department's provided sort of a large number of edits intended to improve the clarity, mostly of the statement of basis and purpose, but there's no substantive effect of their proposed revisions, a tracked version of which is at 5. And that's where I'll be working from myself mostly. The only sort of major revision to the text of the rule that the law department made was removing the phrase "by operation of law" from Exhibit 5, page 15, line 4. And it was removed in large part because it was sort of unhelpful and didn't really provide the clarity that was intended to be provided. So that was the major revision to the text of the rule. Everything else was in the statement of basis and purpose. And we've received some sort of questions about some of the questions about how the how the boards and commissions factor of 1017A1 works with respect to public servants who might have positions on boards as part of their existing city job. And sort of the canonical examples of this are that the HPD commissioner sits on the board of the Housing Development Corporation. The HRA commissioner sits on the board of the Health and Hospitals Corporation. As applied to those people, they would be prohibited from appearing before their city agency, the HPD commissioner before HPD, the HRA commissioner before HRA. They would also be prohibited from appearing before that board or commission. The HPD commissioner would be prohibited from appearing before the HDC board, and the HRA commissioner would be prohibited from appearing before the HHC board. And the same would be true of former employees of their agencies. And the principle being that HRA and HPD have institutional representation on those boards. The agency is present at those boards in a way that is not the case where you have a public servant who might have multiple appointments sort of just separate from their institutional roles. An example of this would be one of the most recent charter revision commissions had sitting public servants on there who had roles at other agencies. And in those situations, we did not expect the board to say that a former employee of the agency that the charter revision commissioner led would be prohibited before appearing before the charter revision commission. Because in those situations, the agency wasn't represented on the board. It was sort of an individual who had multiple appointments from the mayor. And sort of like that's really deep in the weeds. I'm happy to sort of pause there and see if there are any questions about how that worked out.
Chad, let me ask a first question, because I either misunderstand or you might have misspoken. But as I understand it, the scope of the prohibition, let's take the HPD commissioner, who's I guess the chair of HDC. That person, when he or she leaves city service, can't communicate for a year with anybody at HPD, but also, as I understand it, and that's not really what this rule is about, I don't think, can't appear before anybody at HDC, because this was the chair of HDC, anybody at HDC, right?
That's right. They have 2 agencies served.
Right. But this goes to the foot soldier at HPD, or the foot soldier at HRA in the case of a proposed appearance before HHC. Their prohibition is much narrower.
Yes.
At the second agency.
Yes.
Okay, then we're on this
board.
Right. Okay, so the idea is they can't appear before, broadly stated, that person, and so my question is really this: does this language capture that? And maybe we don't quite intend it to be overly precise, because I could read this as saying what I thought you had said, and maybe I misunderstood, that the former, we'll call it the former HPD employee, couldn't communicate with anybody at HDC in the year. And maybe that's not the worst thing in the world, because if the prohibition is a little bit overbroad, the world's not going to end. But if it's under-inclusive and somebody is going to read this, presuming somebody's going to read this, and it's under-inclusive, then they're going to commit a violation, which is a bad thing. But I read this as suggesting to, again, that hypothetical careful reader at, we'll call it HRA or HPD, who's thinking about appearing before the place where the commissioner sits as a representative. Gee, I can't communicate with that agency at all, because I know it uses the words with any board, commission, or governmental entity, but that, when you talk about communicating with a board, to me, it kind of means the entity, right? The whole, anybody there, coming to the Conflict of Interest Board. You talk to anybody on staff, that's communicating with the board. I don't want to, I understand the board may have been through this a few times, so I don't want to prolong this unnecessarily. And if people are comfortable with at least the arguable slight over breadth of this as one possible reading, then I'm fine with it too. I suggest that at least one reading of that language is that that foot soldier, that somebody other than the agency head at HRA or HPD can't communicate with the entirety of HHC or HDC for the year.
I don't think it's a possible reading of the proposed rule. I think when read in context with the statement of basis and purpose, which is sort of clear about.
Nobody reads the statement of basis and purpose, right? Oh. No, look. This thing is going to go in the equivalent of the orange of the red book, whatever exists now, right? I got to tell you, I spent a lot of time at the board, and it was hard to find the old statements of basis and purposes as a staff member. Nobody's going to look at these statement of basis and purposes in the future.
I've experienced that difficulty.
So it's not that way anymore, Wayne. It's not that way.
I'm sure of it, Carolyn. I'm sure of it.
No, but your point is well taken, because we mean something even narrower and than that, because we actually only mean appearing before that board when the representative of your former agency is there.
Right.
The whole board isn't tainted. Oh, you just can't appear before that person. So we actually mean something even slightly narrower than you think our misreading is. So we'll take a crack at adding something so that the rule makes that clear, because then it would make it hopefully even more clear that you weren't, unless that HRA representative is wandering through every hospital, you're never going to have a problem most of the time.
Because there are going to be situations where the employee of the former the employee of the former agency, in the HDC case, the HPD commissioner, is not participating in a matter. They might recuse from a matter, and so we're going to sort of redraft that section of it to sort of accurately capture that it really is that it's that person from the old agency is the prohibition, is the prohibited communicator there. So it will revise that to reflect that sort of that increased clarity.
Just more generally, I think we should revise that, but what is the harm? What is it we're guarding against? If I work for HPD and my former commissioner is now on HDC and I appear before HDC, what am I getting from my former agency? What is it? I'm not appearing before that agency. I'm not appearing on a matter I might have been involved in. I'm not necessarily going to get special treatment by the agency. I'm appearing before a different agency with a different purpose, which happens to have on that agency someone with whom I may or may not have worked in a previous engagement. I don't know what it is we're actually getting.
The concept, Jeff, is that what does it mean to appear before a city agency other than to appear before the employees of that city agency acting in those roles? And if the HPD, if the commissioner of HPD is on HDC's board, then the idea is you couldn't appear before that person. Because, right, and the rest of the agency you could appear before, but just not that one person because of your role as an employee at their agency. So you can't appear before that. That would be the concept.
But I'm no longer an employee, I'm a former employee.
That's right, which is what makes it a post-employment issue.
It's a different agency that happens to have on its board someone who is also formerly employed.
Well, maybe it's not that they just happen to be, it's that in fact the person does that by virtue of their role as head of your agency or as part of your former agency.
I think actually HPD and HDC is a really good example of this because in a real way, they're agencies that are fused at the top, and that there's like a real collaboration and close working between how HDC and HPD each fulfill their missions. And I agree with you. This isn't the sort of thing that we're probably going to be seeing every day. This is actually something of an exotic problem. But in this sort of situation where you're going to have a former public servant making representations before this board that issues significant monies, the fact that they might be communicating with a former colleague of theirs, which is likely if you're communicating with sort of the board at that level of people working, that does implicate sort of like really core post-employment issues. And it's so narrow that it has sort of this serious risk, and it's so rare. It is why we would feel sort of comfortable making this distinction, because this isn't going to be the sort of thing that an HPD employee who's doing regular work with the Housing Development Corporation is ever going to come across. This is something that it really does apply to a certain type of person doing a more elevated type of work, more common.
The other thing I might add to that, Jeff, is it has been the long-standing interpretation of the board, and the board has in fact engaged in at least one enforcement case on this theory. So it's consistent.
Is that right as applied to a staff person other than the agency head? The agency head's the easy one.
Right. We've only done it. The only case I'm aware of is involved an agency head. Yeah.
Let me just for the sake of prolonging this and maybe being a troublemaker, but Jeff's question got me thinking, and the answer is correct, that you're trading on the fiction is, and it's the same fiction of all of D2. You know everybody in the agency, they're potentially your friend. You're trading on the favor for that 1 year, and we don't like the appearance of that. And so that's why you can't communicate with the HDC commissioner who you knew at HRA. But that would apply equally to somebody who wasn't serving as a representative, right? The example in the old opinion where you had the DFTA commissioner at HHC, and a couple of, Anthony was probably involved in the appointments, those people from NYCHA and HHC who got appointed to the DOE panel. That was social promotion, wasn't it, Anthony? No comment?
It was just my job.
Yeah. It was a brilliant move, by the way. It was a brilliant move. But you know those people just as well, whether their appointment to that new body is by virtue of law or just by virtue of the discretion of the appointing authority. So why do we care?
Well, I would say we care because it's...
Why do we care in the one case and not in the other is what I'm wondering.
I would say we care because that's the restriction in D2. Is that the restriction in D2 is only for my former agency serve, and that the D2 doesn't prohibit me from working with people I work with at other agencies, even if I might, as in my role as an advice attorney, I deal with people who are non-COIB much more than I deal with sort of internal COIB things. And the D2 restriction doesn't apply to my communications with the Department for the Aging or DCP or DYCD. And that's just the scope of the restriction that in the charter. And I think there's a sense to which that that's sort of a legalistic answer, but that is the scope of the restriction that people are bound to. And it's intentionally meant to be sort of—
That works for me. That works for me.
And so, there's sort of anything else other than sort of our direction to redraft Exhibit 5, page 15 lines, basically 1 through 4, to sort of more specifically capture that that it really is the representative of the former agency that's the issue?
Like that's it.
They're actually appearing before that representative, right? Not before the body.
Yeah, that person.
That person.
That sort of to really clarify how narrow that it is that person who is the problem for the former public servant.
I've got no more comments on the rest of the proposal. Does anybody have any more? Any comments on the rest of this, the rest of the text? I do not. So,
I do. I'm afraid on. Are you talking about the rest of 107 or just A?
oh, I was referring to the entire section. So
I'm
Yeah,
afraid. I'm afraid I'm still prolonging this on B. I got some concerns about B.
please continue. Prolong. That's good.
I'm using up my quota. I'm sure. Chad, you want to lead? You want me just to jump in on B?
Why don't you just articulate sort of the comment that you had, and then I can respond.
Maybe just by way of example, and that's the example from the advisory opinion that you cite with this fellow who had 15 months of comp time and took 3 months, I guess, of comp time before retiring, and so was off the job. Okay, got paid out for 15 months of comp time, I guess 3 months before retiring and then 12 months after. The question was, when did the clock begin to run? And packed the bag up 3 months before actually retiring. So it was July left and stopped working. October officially retired, resigned, whatever. And I think the board rightly said October, right? But I don't understand how this language works. Maybe the word "or" is the word that confused me. The last day they performed official duties, that person's last official day was in July, right?
Yes.
But they received benefits conditioned on current city employment after retirement.
So Wayne, would it address your concern if on Exhibit 5, page 15, lines 9 to 10, we just removed performed official duties, city duties, and then it's just solely keyed to receiving benefits conditioned on current city employment?
I think probably, and it's hard to know with all the examples because this stuff. But I think it would, because generally speaking, the people stop, then they continue to. They're on annual leave, whatever you call it. Maybe it's not comp time; it's annual leave for a bunch of months, and then the retirement date comes. And I guess the money they receive after is money that they don't get based on current city employment.
That's right. So just so people who might not be, Wayne and I understand what we're talking about. The question is whether or not—
You flatter me.
The restriction in B1 accurately captures sort of the holding in 2019 one, where a former public servant had a question about whether or not his one-year ban had already expired. And the question was complicated by the fact that they, prior to retiring, so that they could claim all the accrued leave that they had not taken, took 3 months of a vacation to spend down the accrued leave to the point that they could then retire and receive the rest of their accrued leave as a former public servant. When former public servants retire or resign, they receive sort of the balance of their accrued leave over time. He worked for an agency that only permitted 12 months. He had 15 months, so he took a 3-month vacation and received the 12 months as the balance. And here, by removing performed official city duties or, the whole section more closely tracks the board's holding in 2019-1.
Yeah, I think that probably works.
Well, another option might be to change the or to an and add the words ceased to receive benefits conditioned upon. So that they are both no longer performing services and no longer receiving benefits conditioned on essentially being a current public servant. I suppose you could still eliminate the end, which I think is maybe redundant with the phrase at the beginning, former public servant.
Or works better than and. Isn't it? Because if you say and, then you're continuing, it implies you're continuing to perform city duties while receiving benefits. So we're saying you're not performing city duties any longer, but still receiving benefits. And that would be your termination. So I think I think it works, eliminating the concluding part of that sentence, leaving the or. I would think.
Yeah, I think that works. So let's so if that works for the board, we can make that edit.
Let's hear it. How would that read now?
How would it read now?
Chad, you want to do it?
So if I understand correctly, the proposed edit would make the provision read, for the purposes of Charter Section 2604 D2, the date of termination of a former public servant city service is the last day such former public servant received benefits conditioned upon current city employment after resigning, retiring, or being terminated.
Oh, but I thought we were getting rid of the last phrase.
Oh, we're keeping the or. I'm sorry, Jeff. I didn't hear you correctly. I apologize.
We're keeping the or, and we're just getting rid of the last phrase.
Which are we getting rid of?
After resigning, retiring, or being terminated, if I understood correctly.
Why are we doing that? How is that? There's no situation. I thought that the concern is that there's no time where someone's going to be performing official city duties and not getting compensated in some way for not receiving some benefits, right?
Right.
So that phrase has no significance.
Well, you may not have retired. You may not have been terminated. You may not have yet retired. You're on terminal leave, but you're still receiving your benefits, still receiving your health care benefits, your pension is accruing. So by simply saying when you've finished performing your duties, or when you're no longer receiving benefits, the later of those two is your final day of employment to measure your work.
Jeff, let me try this. Maybe even shorter. Maybe this is getting at it. What if it says it's the last day after you receive benefits conditioned upon current city employment, period. I mean, the fellow who spent down the 3 months on vacation was getting health benefits, presumably accruing pension credits, was eligible for, I don't know, the litany of things, but wasn't working. So the getting rid of performed official duties doesn't really add anything. And I'm not sure what after retiring, resigning, or being terminated means, because if you've truly retired, you're not getting anything based upon quote current employment because you're not a current employee anymore. It's almost redundant. It's almost a tautology here. But I think but leaving in the official duties, I don't think adds anything because the guy in the AO and a lot of people take that long leave before they retire for the purpose of spending it down to get it within some magic limit that's set at some agencies and not at others, and maybe different categories of employees. I don't know, but I may not understand your suggestion, but that's at least one friendly suggestion.
So I think as to your suggestion, Wayne, I think it makes a lot of sense to take after the phrase, after resigning, retiring, or being terminated, because then you're no longer in city service. But I don't really see the harm in leaving it as is without that phrase.
Well, because the or then is what would confuse me, because if I read that, the fellow on the opinion example who it's the last day he received, last day he worked, or the last day he received benefits. Those are two different dates, 3 months apart. I suppose you could say whichever is later, but we mean the later date. Why do you need the earlier date in there, which is the date that he stopped working?
You don't. I think it just conveys the concept that when you finish performing your official duties, the time will begin to accrue. But if there's a situation where you continue to get benefits, you're on terminal leave, under those circumstances, we're going to count that time, and your tolling date is going to start later. I think the common understanding would be your 1 year begins from the time you finish performing official duties. But if you're continuing to receive benefits, then we're going to look at when those benefits end. I think it really explains what the situation is. It's a little confusing to say the time begins when you cease to receive benefits. But really, the concept really is when you cease performing your duties. But of course, if you're continuing to receive your benefits after stopping your duties, we will take that. We will add that.
I don't want to muddy this even more, but I understand you could say not only stop working, but also ceased receiving. I don't know.
We can try to redraft this as a conjunction of the two rather than a disjunction, rather than an or. If the or was the thing that was being confusing, we could try to redraft it so that it's an and it has to come back to the board anyway. So we could see how the redrafted language addresses that concern. To redraft it so that it's not confusing.
Anything you can do, Chad, will be helpful and appreciated. Anything you can do along those lines would be
Amen.
That was a lot. So we'll redraft one to reflect both, to retain both concepts, but so that it's drafted as an and, to keep both.
Any comments on any other portion of this amendment? Okay. So it will be brought back at a subsequent meeting, hopefully next meeting, and we will consider it further. So I think we've completed the work of our open meeting, having looked at these three proposals. And so there being no objection, I will declare the open meeting to be over. And we will continue the meeting.